Hi, we're talking about Your Money Matters on NDTV Profit, and my name is Alex Matthew. One of the most durable forms of wealth is physical assets, and within that, we're talking about real estate. And so when you're talking about your legacy and you're talking about inheritance, then you want to make sure that the asset that you create or the asset that you buy in your lifetime gets transferred to those that you want to receive it. What are the rules that govern inheritance of both real estate, that is flats and other property, and land? And does this change based on the region of domicile, based on the state that you live in? Does it change based on your religion? And does it change based on your sex? All of these things are what we're going to talk about on today's program. Joining me is Bijal Ajinkya, who's a partner at Khaitan Co. Bijal, thanks so much for taking the time. Let me first ask this, and we're specifically doing a carve-out of that entire inheritance piece, and we're specifically talking about real estate and land. Are there specific rules, first of all, that govern just these two assets?
Right. Thanks, Alex. So there are no specific rules which really govern the succession of real estate. It is the same law which deals with succession of real estate, other movable property, as well as other immovable property. So to that extent, based on the succession law which a particular individual is subjected to, those rules will really govern the succession to the real estate in itself.
Okay, so therefore, the first thing to identify is which act refers or pertains to me as an individual, right? And what could they be?
So there would be like your personal succession laws. So you would look at as to which religion which you are really born to or you are really following. And to that extent, whether it's the Hindu Succession Act, the Indian Succession Act, and so on, would be the law which would be applicable to a particular person. So if we just to put it in perspective, if you're talking about a Hindu, male which is passing away, and if that particular individual has not written a will, then the succession to that real estate would essentially go to his mother, his wife, as well as his children, all in equal proportions.
And so that is the Hindu law. The Indian succession law has a different rule, is that it?
That's correct. So in the Indian Succession Act, it goes to wife as well as children, does not go to mother. And of course, if at all you are from Goa, you have like a communal property law, etc. So there are different rules if at all a particular person is a domicile of Goa. But Goa is very, very peculiar given the fact that it used to be a Portuguese colony. Until very recently, the Portuguese Civil Code actually applied for succession to property.
And out of curiosity, what is the rule that governs succession of property in Goa?
So it's pretty complex, and it really depends on whether it is self-acquired or if at all it is, bought after marriage. In most cases, in a case where you have actually bought property together, post-marriage, then in that case, there's what we call a joint communal property law, wherein the asset is dealt to be and meant to be in equal proportion. And to that extent, it would go to wife or to spouse as well as children, all in equal proportion.
Interesting. Okay. Now, in the two laws that we discussed first, right, which is the Hindu Act as well as the Succession Act, if you are a woman that owns the property, do different rules apply if you have not written a will?
So if you're a woman and, let's assume you're talking about a Hindu woman and assuming she has not written a will, and what you must know that in a will, you have complete testamentary disposition. So you can write literally whoever you want the property to go to, you can essentially write that. Now, in a situation where you have not written a will, under Hindu law, the property essentially would go to spouse as well as to children, all in equal proportion.
Spouse and children in equal proportion. Okay, understood. Now, beyond this, is there any other, and there's of course the Muslim law that relates to transfer of property, and do Christians have a separate law, or do they fall under the Indian Succession Law?
Indian Succession Act. So Christians fall under the Indian Succession Act and Muslims would go under the Sharia laws.
Okay. And so very briefly, how does the Sharia law work in this case?
So Sharia law has a very interesting concept of wherein property owned by an individual is more communal in nature. So to that extent, a person has complete disposition on property only up to a third of their estate. The balance two-third does need to go by succession law, and to that extent, the one-third of their estate, they can essentially write whatever they want. Now, when you're looking at Sharia law, which is with respect to the two-thirds, which has to go by the Sharia law, vis-a-vis that amount, it is distributed to the extent that it go to father, spouse, children in very, very different ratios. So there is like a 1/6 sharing, they have something called sharers and residuaries, and depending on the type of property and the heirs who are living, you would really divide the sharers as well as the residuaries accordingly.
Interesting. Okay. So, for the purposes of this conversation, let's restrict ourselves to the Hindu Succession Act as well as the Indian Succession Act, right? And let's talk about a situation where you have land or property that you want to go to a specific person. Of course, you can write a will, but you and I both know that will can down the line be contested. Is there some way for you to ensure, either through the will or through transfer beforehand, Bijal, that this is not going to be a problem and that this assets gets distributed based on what you want?
Very good question. So I would say here, what you could really look to do is one, I would say that, has the property vis-a-vis the person's name who should be on the property should be the true owner. It's very, very common wherein you will write different person's name as the owner to a property. And what we must note that unless the sale deed specifically provides that the ratio of ownership for this particular portion or for this particular property is an XYZ ratio, it is deemed to be equal. So let's assume that A, B, and C buy property together and the title to the property is in A, B, C's name. However, if only A has contributed to the property and assuming the sale deed does not say that B and C have only been added for convenience and they actually have a zero share in the property, in that situation, it's deemed to be equal. So your 1/3 is for A, 1/3 for B, 1/3 for C. So whenever I'm giving away the property under my will, it will only be vis-a-vis that 1/3 share. So that's one important point, that ensure that your joint ownership is very, very clear when it is meant to be joint at the start itself. Second important point to consider is writing of nominations. Now, very often families do believe that just because I have written a nomination in the society, that is correct and is going to be the owner after I pass away. Important to note that a nominee is not the true owner, and the true owner will be under an undisputed will or under the testamentary laws if at all a person has not written a will or if at all the will is considered as invalid.
Okay, so just to make sure that everybody understands this and are on the same page, in a hypothetical scenario, if I'm the owner of a property and if I've nominated my child as the nominee in the society, this does not require me to go to court, etc. I can simply go to the society and get this as a document or provide them with information. But in the event that I pass away, my child is only the nominee and not necessarily the true owner. That true ownership can actually transfer to my wife as well as my child. Is that the right understanding?
Absolutely.
If I've not written a will?
Absolutely. That is the most important point to note. And the only reason why a society will insist on a nomination is because in your absence, they want to know who is the person who's going to pay the membership fees, who is the person who, notice for meetings has to be sent, who's going to exercise voting rights, and so on and so forth, pending the person who is the actual owner. So that person, I would say in the loose sense, is more like a power of attorney holder who's only acting on your behalf, but is not you at all.
Understood. Also, in terms of the joint ownership, this could create a problem down the road, right? So, for example, if a property is owned by my parents, jointly, and they're both on the name card or on the property document, and so therefore if my father is writing a will to me and is willing that property to me, it can be challenged down the road saying that my mum owns half and she has not separately willed that part of the property to me. That can be a problem, right?
Right. So that may not be a problem absolutely simpliciter, but yes, if at all, let's assume dad gives the property to one child, mom gives that same property, the 50% to another child. It may be highly inconvenient for two individuals to really occupy that property. And of course, if at all the other child or other sibling comes up with a will wherein the mother has also given it to the same child, those are all chances of a contest. So it is very, very important that where a property is jointly held, and it's very often jointly held for whatever reasons, in that situation, do ensure that both the owners are actually giving the property to the same heir. It's always a better thing to do.
And a joint will can be written from that perspective, right?
Right. So a joint will can surely be written. However, what we must note is that in India, it's not very popular to write joint wills, and whether or not it will be understood in the form in which it is supposed to be understood is a big question mark. So we would always suggest have individual wills, which may be mirror wills, but do not really have a joint will per se.
Understood. Okay, that's an important clarification. And so, which brings me to the final question, which is, why wait for the will to be written? Can you not transfer the asset that you intend for your child or to the person that you want to will it to before your death? And this is something a lot of people are contemplating, particularly for property, where you have the right to occupy the property. You can put that as a precondition when you are doing this transfer. The only sticking point is that stamp duty and the cost of transfer, right, Bijal?
Absolutely, absolutely. So one way in which you can do a lifetime transfer and not really relying on a will, which could possibly be contested, is one, you do an absolute transfer by way of a gift, which is where you will land up paying the stamp duty. Second, you can do a sale, and again, you will pay a stamp duty, and of course, it's money really moving around. The third, which you can do, and why a pure gift, though in most states, the stamp duty for a gift is much lower than that for a conveyance. Why many parents will be concerned of doing a pure gift is because they may yet want to have ownership rights to really live in that flat. Now, in that situation, what you could look to do is you can transfer the property by way of a gift by retaining what we call a life interest. So in my life, I have a life interest in that property. I can use it, I can enjoy it, I can do whatever I want with it, other than the fact that I cannot sell it out because I've already transferred ownership to the next generation or to whoever I want to be the heir.
And is it true that in certain places, and I've heard that Uttar Pradesh is one of those, that they actually allow you to waive stamp duty if you're transferring to a blood relative?
A lot of them did have. In fact, even in Bombay, we did not have a stamp duty. If at all, it was to a relative. But of course, we now have the metro cess. But many states actually do not really have a stamp duty. If at all, it is going to the family in itself. However, you would need to look at the state in which the real estate is situated to come to the conclusion as to how much is the stamp duty to be paid.
Understood. Okay, so in Mumbai, you don't have a stamp duty that is paid even currently?
So in India, you have a cess to be paid, and you have an extremely low stamp duty for transfer between relatives.
Okay.
Now, important to note, the definition of relatives is more lineage in the sense of going down. It doesn't really include going back up. So today, if at all I want to gift a property to, say, my parents, that is not considered absolutely tax exempt. So there stamp duty exempt. So there is like a 2%, which is lower than your 5% stamp duty, which has to be paid.
In the case of transfer of daughter to father or
That's correct.
Okay,
if it's going upwards.
Understood.
Yeah.
Understood. Just a last point, Bijal, which is, and we've spoken about this on another program, which is a Hindu undivided family and the complications that might cause. And a lot of people are getting into this kind of a structure thinking that it is more tax efficient, but can it prove a challenge when you're trying to transfer property in particular?
Absolutely. What is important that you could have an Hindu undivided family, which is a separate taxable unit, or you may not really have the joint family property put into an HUF in the sense of a tax unit separately, and it may just be co-partnery. What is important for us to know is that every lineage who's born, out of the male lineage, are all considered as co-partners. So today, for instance, let's assume you have a co-partnery, which is between three generations, and each of those generations has contributed efforts, labor, or for that matter capital to the creation of this property. What each family member really has is a co-partnery interest in the property, but you do not have an absolute interest, as a result of which it becomes important for you to transfer the property only vis-a-vis your own co-partnery interest. Now, let us look at a situation where we are talking about real estate, which is the subject matter for today's discussion. Imagine a case where you do have the remaining family members who are all co-partners owning that property, and I, in my will as a co-partner, I give my co-partnery interest to, say, a third person. Now, it is absolutely, I would say, impossible for a third party as well as a family to cohabitate in a particular real estate.
Yeah.
So it's not really the best thing to really do. So what would be a good thing to do is essentially dissolve the entire co-partnery or the HUF and ensure that it becomes each person's individual property,
Sure.
as a result of which they are in a position to individually deal with that property.
Understood. Okay, important conversation today, Bijal. Thanks so much for taking the time and for making this relatively easier to understand.
Most welcome. Thank you so much.
All right. Right. Well, there you go. Everything that you need to know about transfer of real estate, and some interesting points about transfer in a linear manner from father or mother to daughter or son, and not the other way around.